Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to go back on an issue we've talked about before, which is this dreaded age of purgatory, 18, 19, and 20. Because as we know, you're old enough to, well, be convicted of an adult crime and sent to prison. You're old enough to serve your country. You're old enough to die for your country. But apparently government does not think you're old enough to own certain types of firearms. And there's actually federal law that prohibits anyone under the age of 21 from purchasing a handgun. Think about that. You're an adult once you turn 18. You have all these other rights and privileges that come with it, but you don't get a handgun until you're 21. I thought we had a constitutional right to that. Well, there's a huge ruling, and I do mean a huge ruling. We're going to talk about it today because it's not only the ruling, it's the remedy here, because we're talking nationwide injunction for everybody 18, 19, and 20. I'm not joking. Let's get you filled in. So today, let's talk about a huge ruling that could benefit millions. Okay, so the case we're going to be talking about today is Frazier versus ATF. Now, it is a case that is filed in the United States District Court for the Northern District of Virginia. And this case was actually decided on the merits back in May. Let me explain. The plaintiff here, Mr. Frazier, who is somewhere between the ages of 18 and 20, was obviously denied purchase of a handgun, challenged the constitutionality of 18 U.S.C. section 922 subsections B and C. There's very clear language in there that prohibits people under the age of 21 from purchasing a handgun. He challenged the constitutionality of that statute, and in May, the judge in this case issued summary judgment in favor of the plaintiff. That is basically a directed verdict that says, hey, I've reviewed the law, I've reviewed the facts, taking the evidence in the light most favorable to the United States government, they still lose, and he granted relief and a judgment for Mr. Frazier. That's the first good news, okay? But then there was a, what is the remedy? And of course, the United States government was saying, well, we're going to appeal this, and there shouldn't be any remedy, and if you're going to enjoin, it should only be the named plaintiffs here. However, the court had previously ruled that they were going to designate this as more of a class action suit. That is, who is the class of individuals that is affected by it? And what the court came to a ruling of, and it's a pretty obvious ruling, is it would be every American age 18, 19, and 20 who were otherwise lawfully allowed to possess a handgun, okay? That's the class that we're talking about, okay? So the judge has now said that this ruling will apply to everybody in that age group around the United States. Second piece of good news. Third piece of good news, and this is huge. What is the remedy now that the judge has found in summary judgment that this law is in fact unconstitutional? What the judge is proposing here is a nationwide injunction. Let me say that again. A nationwide injunction against 18 U.S.C. subsections B and C, the sections that deprive individuals 18, 19, and 20 years old from being able to purchase a handgun. This is potentially huge. Now, some of you probably have state laws, which are going to have to be challenged separately. Washington State, for example. We have plenty of state laws that also forbid this, but many of you may be residing in states where, but for the federal legislation, there is no other prohibition on it. And if this is in fact the remedy, there is no prohibition right now on that. In deciding that a nationwide injunction was appropriate, the court very correctly ruled people between the ages of 18 and 21 in the Eastern District of Virginia suffer an equal burden as the people of the same age in the Southern District of New York, the Central District of California, or any other district. The government's policies affect and harm each of them equally. Therefore, the categorical policies relied upon the government call for categorical relief. Only a nationwide injunction will prevent the irreparable injury to plaintiffs who, since as class has been certified, include all American citizens between the ages of 18 to 21 who are otherwise qualified to purchase a gun. Now, obviously, that is huge news. Now, in the underlying ruling, what the plaintiffs had argued here is, listen, you can't go back and find any historical analog that bars possession of people based in this age of purgatory. The court very correctly ruled, the government's argument is predicated on a limited and erroneous reading of the fundamental right protected by the Second Amendment. The Second Amendment protects the right to purchase, not just possess, a firearm. Now, one of the arguments that the government made is, hey, there's no harm here. These 18, 19, 20-year-olds, they're not harmed because at some point, presumably, they'll all turn 21 and they'll be able to enjoy that right. The court was not persuaded in ruling. Contrary to the government's view, it does not matter that one day plaintiffs will age out of the prohibited category. Since they turned 18, at this moment, at this point in their lives, their constitutional rights have been and continue to be denied by the government's conduct in enforcing the challenged statutory and regulatory regime. The government also said, well, listen, they might not be able to go buy handguns, but they could, in fact, be gifted the handguns. So the ability to exercise the right would, of course, be based upon the generosity of an unnamed third party. As the court correctly pointed out, nor is the irreparability of the constitutional injury eliminated because, as the government argues, the plaintiff and class members may lawfully obtain handguns as a gift from their parents. Nothing in the Second Amendment limits the plaintiff's exercise of their constitutional rights to what a third party, by grace, may choose or not to do to help plaintiffs exercise that right. Here, the right to purchase that which the Second Amendment entitles them to purchase on their own. Now, there is one caveat as you get towards the end of the opinion, and we're going to link it all up down there so you guys can all geek out on yourself. The judge did not impose an injunction in a couple of jurisdictions. It has something to do with parallel litigation. I didn't have a chance to geek out and look deep enough into it, but I have a belief that there are probably parallel suits involving exact same issues in these jurisdictions in which the judges there are about to issue rulings as well. But just so you're clear, whether this injunction applies to you or not, it applies to everybody 18, 19, and 20 in the United States who's otherwise lawfully allowed to possess a firearm, and of course who doesn't have a state law that prevents it and does not fall in one of these two jurisdictions, because as the court put it, however, in recognition of the currently pending parallel litigation concerning the challenged legal regime, the injunction will not apply to the Western District of Louisiana and the Northern District of West Virginia. So there is at least one judicial district in Louisiana and one in West Virginia where the court has specifically stated this does not apply. That has to do with parallel litigation, which means presumably we have another judge that's about to issue a ruling in another named case involving exactly the same issue. Now, obviously, the United States government has already crapped its pants. Obviously, they're going to be appealing this, and this is not the end of it for now. They will obviously be arguing to a higher court for a stay of this injunction, but all of this is going to come to a head here as it relates to a nationwide injunction, probably in the next couple of weeks. So we're going to have to very carefully watch this case. The case, once again, is Frazier versus ATF. The ruling, once again, is that 18 U.S.C. 922 sections B and C, which prohibits people 18, 19, and 20 from owning a handgun, is in fact unconstitutional. The certified class for that suit is every lawful American 18, 19, and 20 years old, and the proposed remedy by the court is a nationwide injunction prohibiting the United States government from enforcing this law. We will keep you posted about this case. We're going to carefully watch it. As there are more updates, we will let you know. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is right down there in the description box. Now, in the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.